Hey, it's Brian at Showcase Agency, and here at David Libman's office today, we're going to talk about putting homes in trust and the importance of a trust. And David, first of all, I just want to say thank you so much for allowing us to be here.
Thank you so much for having me.
Great.
Really appreciate it.
Great. So let's start by talking about what is a trust.
A trust essentially is a vehicle that people use to avoid probate. I mean, there's a lot of things that you can do with a trust, but when you die, there's two paths typically. I mean, there's many, but there's two paths that are going to happen. One is if you don't have a trust, and in California you have assets that are over a certain value, in this case about $165,000, and that could change. We're sitting here in 2021. But if you have assets over a certain value and you don't have a trust and you don't have those assets in the trust, then you're going to have to go through probate. And what probate means is you're going to have your estate go through the court system, and there's statutory fees, and there's all kinds of things that you don't want your beneficiaries or people that you want to inherit from you, you don't want them to have to go through. It's no slam on the court system, but anytime you can avoid going through the court system, it's great. So trust is a vehicle where you basically set out your estate plan and it goes to the trust and it doesn't go through the court, and that's always good.
Okay, that makes sense.
Yeah.
So what are the type of assets that are held in a trust?
It can be anything and everything. It can be personal property. It can be real estate. There's certain assets, for example, when I do an estate plan, that never go through a trust. You don't want to stick your IRA in a trust because in a way an IRA is almost like its own trust. You don't want your 401k in there. But bank accounts, cash, stock, your real property usually in California is one of the big ones, because most people's houses in California are worth more than that probate limit. So you want to get your house deeded into your trust before you die, so that when you die, your trustee can just pass it on to your heirs instead of dealing with the probate process.
I'm glad you brought up the probate process. A few years ago, we had a client. She was would she be the executor of the trust if she was the one that was in charge once her mother passed away?
And that's a great example. So if it goes through probate, you've got a will, and the person that's in charge of the estate, if you have no trust, is called the executor on a will. With a trust, it's called the trustee.
Okay.
Yeah.
So what had happened with her, or with her mom, is the mom had a trust. The mom refinanced her home, her primary residence, and then when the home had been refinanced, it was not placed back into the trust. And so they had a trust. They thought everything was the way it should be, but when the mom passed away, that home had to go through probate, even though they had the trust. So how would somebody know if somebody has refinanced, how would they know if the home has been placed back into the trust?
It's great you asked this, by the way, because this happens all the time. This comes all the time, and it's an unfortunate thing. It depends on who you're dealing with. Sometimes when, I don't know, when people sort of deal through your agency or whatever, sometimes when you do refinancing, somebody as a courtesy in that process might say, we'll do another deed to put it back into the trust for you. Rarely does that happen, because most of the time, and I understand it, the lender wants to make sure that the actual person is the borrower and listed, and that's why that deed goes that way out of the trust for the person to refinance on the trust. So usually after the fact, you need to do another deed where you transfer back from, say, if it's Brian Smith's trust. I mean, if it went to Brian Smith as the owner, Brian Smith's the borrower, he has to do a deed from you, Brian Smith, to you, Brian Smith, trustee of the Brian Smith Trust. Right. And so all deeds are recorded with the county recorder, but it's not like regular people are necessarily looking that up. So it's time to call your, real estate lawyer at that point, or if you've got a real estate agent or broker you trust, you can ask that, or you can go online and check on the recorder's website. But most people don't necessarily know where to find those things. But yeah, you want to make sure that there's a deed recorded back into the trust.
Because if you don't, then you're going to end up like this person I was just talking about, and you're having to go through probate, which is what you were trying to avoid anyway.
Exactly.
Yeah.
Exactly.
Now, there's a few different types of trust, right? Now, I've heard of a revocable trust and irrevocable.
Yes.
What's the difference in those two, and what are the situations where one is appropriate and the other is not?
So I always feel that those are unfortunate terms, but they are what they are. You're exactly right. There's revocable and irrevocable. Revocable trust means that it can be revoked by the person that set it up, meaning that I set it up, but it's not etched in stone. I can change it.
Okay.
So basically, a revocable trust means you can amend it or you can do away with it. An irrevocable trust is the opposite of that. It means that I can no longer amend it. So the reason it's a little bit unfortunate to me with the terms is it gets confusing. If a couple sets up a joint trust, which so many married couples do, then what happens is when they first set it up, typically, it's a revocable trust. While they're both alive, they can both amend it, revoke it, make changes as they see fit. You know, maybe the one kid they think is going to need more money than the other. I mean, that most people give to their kids equal, but you never know. So things happen, right? So they're amending it, or somebody has a new kid and they want to add the new kid to the trust, or whatever it is, ex-wives. All of that can happen, ex-husbands too. But with spouses, once one of them dies, typically, the trust, at least on that spouse's side of the trust, becomes what they call irrevocable. And the reason that is the case is, you know, we have the situation where the one dies and the one meets somebody new, and the kids are concerned that the new person is going to take all the money. So typically that's how it gets set up. Yeah.
Okay.
Yeah.
And what was the question I just had? Sorry about that. So, and we kind of talked, you kind of covered this earlier, but just to be clear on it, if a person has a will, that's not going to protect them from going through probate. They still have to have the trust in order to avoid the probate and the fees and the cost.
Yeah. I mean, the exception would be if you have a will and you have low value assets. You know that when you die, you're not going to have enough money to even trigger the probate process, then it might be enough. But most of the time, for the people that are worried about it, a trust is going to be better. Now, there is an aspect here where even if you have a trust, what you do is you draft a will and you have what they call a pour-over clause in the will, which says, hey, if I forgot to put something into the trust before I died, as soon as I die, it goes into the trust. Most of those assets are worth less than the probate limit, right? So you buy a widescreen TV on the weekend. It's not like you're going to list it in your trust, you know, and then you die on Tuesday, that widescreen TV is going to go into your trust. But the real property, if you just had that clause in the will and you hadn't actually recorded the property into the trust with the proper deed, will trigger probate. The situation you described.
Right. Okay.
Yeah.
And what are there any drawbacks to a trust?
I suppose the drawback to a trust that I can think of is just there's the cost to set it up.
Okay.
I don't think that it's not a significant cost, and if you do the math over time, it's actually less than you would spend for probate, because probate are statutory fees. So, for example, it's a sliding scale, but as we sit here today, if you had $100,000 in assets and you're going through probate, you've got a 4% on the first $100,000, and then it goes down. But trust is going to cost, you know, unless you get somebody exorbitant, you can do that for less than that. Like, I do it for less than that. So,
okay. Yeah. Well, let's talk about that. What do you typically charge? Or I'm assuming it depends on maybe the number of assets or the value of assets, but what would be a range for our viewers so they could have an idea?
Sure. I mean, for me, the way I do it, I don't base it on your assets, and you know, every attorney is different. I have a block rate that I do to prepare a package, which includes a healthcare directive, which is sort of like what happens if I'm in the hospital.
Right. Does that include, so that's basically if I want to be resuscitated?
Yeah.
Okay.
Do I want to be cremated? All these kind of things.
Oh,
so
okay. That is
it's a package. I have a healthcare directive, a power of attorney, a will, and a trust. And if it's a couple, it would be 2 of everything except for the trust, right? 2 wills.
Okay.
And so for at least as of today, sitting here in 2021, when I do it, it's $1,650 for a single person to do that package, and that includes 2 hours of consultation. And then if it's a couple, I charge $2,350 for the couple to do that. That doesn't include deeds to transfer stuff into the trust, because every county has different recording fees. And sometimes with deeds, there's a mess that has to be cleaned up, so it's hard to, I just do that at an hourly rate.
Okay. Now, once somebody has their trust set up, let's say that they sell a piece of property or they buy a piece of property, how do they make sure that that goes into the trust? Because like you said earlier, the pour over isn't going to add that trust or add that property into the trust. So I guess they would come back to you and go through
it's
the
a good
process.
point. Okay, so the selling is interesting, right? That's a really interesting scenario you described, because if they're selling, let's say they were just for whatever reason going to bank the cash. Let's say, with the way California is, they made a lot of cash, right? I always send out instructions to people when they get their trust set up to go transfer your regular bank accounts into the name of your trust, because if you sold the property and you got all that money, you'd want that to go into the bank account that's in the name of the trust, because that's cash that could trigger probate. Okay? That's the more complicated scenario. If you're just buying a place, you buy the place, and if it's you, Brian, if you were buying your place or one of your clients, right, and it's probably going to be first in the name of Brian Smith, not as trustee. And then what you do is you just have somebody prepare a deed that has to be recorded, that transfers that property from Brian Smith, the individual, to Brian Smith, trustee of his trust. So I do that all the time.
So they basically have the deed prep and then the recording.
Exactly.
Okay.
And the deed doesn't cost that much to prepare. The recording depends on the county. And that seems to be all over the place lately. I did one for LA County last week, and for whatever reason, that particular place, the deed was like way more expensive than normal. But usually it's usually $100, $200, depending on the county and the place.
Okay. Yeah. And once the
recording fee.
Right. Once the trust is set up, are there any maintenance fees? I know we just talked about what would happen if their assets changed where they bought another property, but let's say that nothing changed. Are there any maintenance fees that they have to cover?
That would vary. I can only speak for myself, right? Same thing with setting up a trust. With me, there's not, right?
Okay.
I set up a trust for people. Their maintenance fees, they don't pay me anything. If they're transferring properties a lot, they're going to have the fees of making these deeds and recording them into the trust. But in terms of anything beyond that, you might have some fees with your CPA at a point when there's going to be a trust tax return when somebody dies. There's those kind of things, but there's no ongoing annual fees or things like that.
Okay.
Yeah.
And kind of one last question from me is, so let's say that someone, they don't set up a trust, and a property goes through probate. In addition to those fees that they incur by going through probate, and also the drawn out process, what I've heard and what I've seen from some other people is that there's also family members that can come in and they can try to lay claim to that property as well during the court process. Is that true, or do I kind of have it turned around?
No, you do have it right. You've got to notify potential beneficiaries in the probate process. You do with the trust as well. In other words, when somebody dies, you're sending the beneficiaries that are listed in that trust the notice of that. And so if somebody had a gripe about a trust, they could bring a lawsuit. That happens. But I think the difference is, it just seems like it draws that there seems to be less organization when it goes to the court, and more, at least what I've observed, more tendency to have those problems arise. Where you get into problems with the trust, if somebody dies, it's quicker, right? If somebody dies and nobody's arguing, then the trustee just doles out the assets and you're done, right? They do the paperwork. There's an administration process, but it doesn't have to be crazy if the people don't make it crazy. And where you get into issues is parents disinherit one child, or maybe somebody forgot to amend their trust when they remarried, and suddenly the
okay.
ex-wife is still the one getting everything, you know. Or I see siblings that are fighting, and they claim to be fighting about the trust. They do a lot of these lawsuits, but really maybe what they're fighting about is something that happened on the playground when they were 5 years old, and this is the way to get to it, you know. So you can't stop people from litigating, but I think you can at least minimize or reduce those risks with the words.
I see. So you mentioned some life events where somebody would need to amend the trust. Do they got a divorce, or what would be some other life events where they may want to amend the trust?
Marriages, of course, like you say, remarrying, divorcing, those are always. If you have a new child, you know, if there's some significant change in your financial situation, you might want to do it for various reasons. It could be, if you've got the trust worded the right way, buying and selling property doesn't have to trigger an amendment, because it's just a matter of putting the property into your existing trust. You know, in the unfortunate situations where somebody who's a beneficiary has really ticked you off and you want to make sure they don't get something, that would be a scenario to amend the trust. And then sometimes with grandkids, I mean, most of the time the trail is spouse to spouse. So when the first spouse dies, the other spouse receives the trust, then the kids, and then the grandkids. But sometimes people have situations where, for whatever reason, a new grandkid comes along, or they want to skip. I mean, there can be tax issues there, but sometimes there's not, and sometimes people don't care. They still want to make sure people get what they get. And then there's special needs situations. Maybe you've got a grown kid that's going to need care for some reason or another, and you want to make those changes.
Okay, that makes sense. Yeah. David, anything else you think our audience should know?
I think it's, first of all, a real pleasure to have you here, and I appreciate you asking me the questions. As a lawyer, I have to say this shouldn't be construed as legal advice. The law changes all the time, so what I say today could change, and your particular circumstance might be different. But we're speaking in generalities here. From my standpoint, trust, you know, like drafting up estate plans, depending on the year, is usually someplace between 15% and 25% of my practice. Most of my practice is litigation, but a lot of the litigation, because I do a lot of real estate and business, is this trust litigation or estate litigation without a trust. So it's so valuable to set it up the right way so that you avoid having people litigate over this later. That's the important thing, is to get it set up right. You gave the perfect example too. Of course, people can do these things themselves, and sometimes they do a great job. But if you're going to do it yourself, you know, you're like if you're like a non-physician trying surgery, make sure you know what you're doing. Exactly. You know, it's a net positive to do it and make it so that it's clean and nobody's arguing and nobody has to hassle with the court system. That's my bottom line.
Okay, perfect. David, thanks again for having us here at your office. We enjoyed it, and again, thanks so much for your time.
All right, thank you very much.